Mhm.
We'll let you know when we're live, Jim. Should be just a minute.
Okay.
All right. Hello, everyone. Welcome, and thank you so much for spending part of your day with us. And if you are joining us live, feel free to drop a quick hello in the chat. Let us know where you're tuning in from. And as we go through today's discussion, if something comes to mind, put your questions in the chat, and we will make time to get to them during the Q&A. And just a quick note before we jump in, this is a live educational session. And while we will be covering a lot of important information, today's discussion is for general education only, and it doesn't create any kind of attorney client relationship. So, if this is your first time here, my name is Nadine, and I'm part of the Disability Digest, where our focus is helping individuals better understand how to navigate the disability process and make sure that you make more informed decisions along the way. And of course, leading today's conversation is Brian Tarian, our very own CEO and founder of the Disability Digest. So, Brian has spent years helping people break down what can feel like a very complicated system into something that's actually understandable and actionable. And of course, Mr. Philip Price, who works closely with individuals going through the process every day, and he leads a strong, supportive community where people can stay informed and connected throughout their journey. And last but not the least, of course, attorney James Mitchell Brown. He is fairly new to this industry. He brings us over 52 years of experience in disability law, and his perspective comes from decades of seeing how claims succeed and where they often go wrong. And I would like to ask everyone to greet him a belated happy birthday. Thank you so much for being here with us today, Jim.
It's
Happy
great to be
birthday.
here again.
Yes. All right. Is it over to me, Nadine? Is it my turn after that wonderful introduction? I'll take that as a yes. Yeah. Great. Wonderful. Thank you for that great introduction, everybody being here. And Jim, I had a couple of things I was reflecting upon on your birthday. You just turned 80, everybody out there, Mr. Jim Brown. So 2 days ago. And I plan on doing this work at least for another 10 years, and I certainly expect you to be around. So I have a few points of inspiration that I want to share with you as we get started here today. And I'm going to share my screen. So can you see this 2790 that's up there now? Yeah? No?
Yeah.
Nope.
So this individual is 81 years old and he just set a track record running the 200 meter, 29 seconds and 70 seconds. I'm not able to do that. So he's 81. So you have a year to practice, right? So that's number one. Number two, this is a family friend of ours, Flo Myler. She's 91 and she holds 8 world records for senior Olympics, track and field. She does the shot put, javelin, and track events. And so she's 91 doing this. So, I'm not suggesting that you need to do this, but there's great things going on. Your birthday is just a number, is what I'm attempting to communicate. Yes.
All right.
So what we're going to do today is a different type of event. I mean, if you think about it out there, um, of anything that you've done for a long time, right? If you've done anything for 52, 53 years, God bless you. I mean, but this is really a remarkable resource that we have here with us. So I have queued up some questions to ask Jim about, over the 52 years, what are some of the surprises? What are some of the things that still are the same or different? Some of the things that stand out. And the point of the questions is really ideally when you leave here today in this event that you'll be able to get a concept of like how Social Security has functioned and how it will function, because a lot of people unfortunately have to go through and are looking at the Social Security disability process, and they don't have a real clear understanding or a roadmap, and it's like trying to go somewhere without any directions. So that's what we're looking to do. So, and also today, if after the event, if you have an interest in speaking with Attorney Brown, you can contact one of our advocates internally here. They can have a conversation with you, see if it makes sense, and make an introduction. At the end of today's event, we are going to have a question and answer session. So you can type in your questions, and Nadine, are we going to have folks invite them in live too? Okay.
Yes. Mhm.
All right. So two or three people will have the opportunity to come in and like ask your question live and in person. We'll share that link with you. All right. So Jim,
Ready.
you ready to go?
Let's start.
All right. So the first thing is let's start with the fundamentals of the approval process. And if you, what year would it be? Like, what's 53 years ago from today? 70 what?
73.
73. Okay. So starting in 1973, the what somebody needs to prove to get approved for their disability benefits. Has that
There were
changed?
no, there were no standards then. The grids were age, education. It was always age, education, vocational background, and disability. But you were at the mercy of a judge. They weren't judges then, they were hearing referees. And
Referees? Really?
hearing referees, they didn't become judges until 1979. And they didn't have to be lawyers. When they became judges, the non-lawyers were grandfathered in as judges, even though they weren't attorneys. And they turned on their reel-to-reel tape. They didn't have an assistant. There are probably a lot of people listening who don't know what a reel-to-reel tape recorder is. And they would talk to the claimant and gather the information. But there was no standard that said if you prove to this a certain degree, you're going to win. You were at the mercy of the hearing referee.
So what was their criteria?
There was none.
So, okay, if so somebody shows up that they know and they suspect this person is a, honest, hardworking person that just can't work anymore, that's likely going to get approved, right?
There was one judge I knew who, if the claimant cried, he always paid the case.
Oh boy. Yeah.
There was, and at that time, they were paying about 70% of the cases. And there was one judge who was paying, one hearing referee who was paying 18%. And a lot of it was, who did you get to take your hearing?
Okay. Okay. Did everything go to a hearing or were there early application awards?
It was the same as it is now. You had the initial application, the reconsideration, and the hearing and the appeals counsel.
Okay. Interesting. Referees. Yeah, I have a vision of somebody in like a striped shirt, but it's probably that wasn't the case. Mm.
Well, when they became judges, a lot of them thought it was a joke that that was their new title. Uh, in the Cleveland office, one of them went to a costume shop and bought robes and had them take a group picture to hang in the lobby. But as judges, they didn't really wear their robes for hearings until the 90s, when a new crop of them came in. A lot were ex-prosecutors, and they took the title seriously and wanted to wear their robes for hearings. And that's when they began doing it.
Wow. Times have changed.
They sure have.
Okay, so what's on my mind next is what people misunderstand about the process of getting approved, staying approved today. We can even focus on just getting approved. That was also misunderstood, decades ago.
Big misunderstanding, and I've said this on past shows, is that a diagnosis is not a disability. And a lot of people will see in the Social Security standards a diagnosis. MS.
Yeah.
MS by itself isn't a disability. It's what limitations does that diagnosis give you?
Mm-hmm.
A lot of people say, well, my doctor says I'm disabled. A doctor's saying you're disabled doesn't get you disability unless you're paralyzed or blind.
Yeah.
Disability is a legal determination. The doctor has to say how much you can lift, how long you can walk, how long you can stand, how long you can reach overhead. But there's over 100 different definitions of disability in America. So if a doctor says you're disabled, does that mean you can't do your past work? Does that mean you can't do light work? There's too many definitions. So the doctor saying you're disabled doesn't mean anything. Years ago, I was at a dinner with a doctor from the Cleveland Clinic who didn't understand why, when he said someone was disabled, they never got their Social Security. And I said, you just sent me a letter. You said, I've been treating this person since 2002, and they became disabled on March 1st, 2021. I said, give us a clue. What did you treat them for? Why did they become disabled on that day? What treatment did you give them? What worked? What didn't work? And he said, you mean somebody's interested in that? And I said, I know you're an SOB and you wouldn't say somebody's disabled if they weren't. But Social Security doesn't know that. So you have to tell them why you treated that person.
Yeah. It's interesting in all the time that you've been doing this and myself for just a fraction of the time that you have. We continue to communicate the importance of communicating limitations. And I'm in hopes at some point in time that we will start making a significant dent in it. It's critical for people. It's really one of the biggest challenges. Anyway, that's my quick rant.
One other thing you should know, when they were hearing referees, a favorable decision was one pre-printed line that said the claimant is found to be disabled, effective. The hearing referee hand wrote in a note and signed the form. There was no long, detailed explanation as to what they found, which made it much easier to approve a claim than to deny the claim. Although a denial was still only about 2 paragraphs, most of which were pre-printed, until the court said you have to give explanations.
Yeah. Well, in today's world, the initial and reconsideration approvals are just an award letter, so pretty simple, right? Standard stuff.
AI is writing the denials now.
Are they writing decision letters too?
Depends on the judge.
Huh. Yeah. I mean, I can see where there's some efficiencies there. What about the medical evidence and doctor documentation as we kind of roll into this? Would you say it's become more important over time to get through the process?
It's extremely important to have good medical evidence. And one of the things I tell my clients is the doctor walks in and says, how are you? And you say, fine. Never say fine. Tell them what's wrong. immediately start with what's wrong, because a lot of times the people at Social Security read the first word of a doctor's office visit
Oh,
and
yeah.
it says you're fine. And then they don't read the rest of what's wrong, that you can't stand, you can't sit. There's something called a medical source statement, which Disability Digest has on its website. Those are important. That's where the physician tells what your physical limitations are. And you need those. It's almost impossible to win a case without a medical source statement. And
Yeah.
that has to tell what your limitations are. And those are crucial. My letter to the physician says your patient has almost no chance of receiving benefits if you don't complete this form.
That's strong.
A little guilt always helps.
That is strong. And if you're listening out there, a lot of people look at it, in my opinion, Jim, it's extra work. They can't be that serious about it. I'm not able to work. I should qualify. But the fact is, in today's world, it's just the reality of it. So
One of
if you,
the interesting things, and this is an informal survey I did when I spoke at the American College of Rheumatology, American College of Orthopedics, and American College of Urology, 70% of the physicians don't know the outcome of a case. They fill out the forms, they send the records, and they don't know what happened. I always send a thank you note to the physicians who filled out forms, thanking them for their help, and enclosing a copy of the decision, highlighting where their name is mentioned, so they see that it was important what they did for me.
what a great idea. Wow. Yeah, no, and they deserve it, for sure. Sure. Jim, uh, if there was a number one thing that you have commonly seen that goes wrong, is there anything that stands out, falls in that category?
Well, let's do a little history first.
All right.
In the 80s, when they were trying to cut 500,000 people a year off of disability, and DDS, the state agencies, were sending forms to doctors to fill out. They were intentionally misleading them. I had a young lady sitting across the desk from me who couldn't see me, and yet the doctor wrote that her vision was 20/60. And I called the doctor and asked him why he wrote that. And he said, well, the question was, what was her best visual acuity in the last 12 months? And he said she was in a dark room. The medicine was working perfectly, and it lasted about 20 minutes. And I said, well, what is her vision? And he said, corrected, it's 2600. She's legally blind.
Oh boy.
And I said, why didn't you write that? He said, they didn't ask that question. If you have certain joint impairment and certain positive blood tests, or certain pulmonary problems with certain pulmonary tests, you automatically win. But they stopped asking for that. They still don't always ask for lab work or pulmonary tests. You need your doctor to send all their records, including their lab work, their pulmonary tests, if it's a heart problem, their EKGs, your stress tests, whatever you have, because those are the tests that help you win your case. Um, if you don't do that, they're not going to have the evidence to pay your claim. They don't always ask for it. So you have to tell your physician to send everything.
Mm-hmm. All right. I'm gonna go and maybe off track a little bit here. So let's take veterans, for example. There's a couple challenges there. Maybe you have experienced this, is getting the VA to release medical records. That's been a problem, and also getting VA to authorize um, RFCs, medical source statements. So for those individuals that try and are denied, is there any workarounds that you've seen over the years? And then the second part of that question is, has it always been that difficult? Like not just with the VA, there's some other doctors, like, there's But yeah, that's my two-part on this.
It's always been difficult to get doctors to fill out forms. They're too busy. They don't know. The VA will send you their records. You have to ask for their C file, C like Charlie.
Okay.
Sometimes I will send my client to get their C file. There's one particular judge who is an extremely low payer, and I recently filed a 19,000 page C file.
Mm-hmm.
And he asked me why I filed such a big record. And I said, well, the rules say I have to file all the medical.
Yeah.
The VA has a memorandum saying the doctors are permitted to fill out forms for Social Security. It doesn't mean they will. The mental health docs at the VA usually will. There's a couple chiropractors who work at the VA who usually will fill out forms. Most of the others won't.
Mm-hmm.
Once in a while, a neurologist or a cardiologist will. But
Mm-hmm.
most VA doctors are under a lot of pressure to see more patients than they've ever seen. They're usually given 6 to 7 minutes per patient.
Ooh,
And that doesn't leave them time to fill out forms.
no, no. Do you ever advise people to fill them out and bring them in, ask them to sign it? This is what's going on with me. And does it work?
No, but I've advised people to fill it out and bring a blank one in and
Yeah.
ask the doctor to look at what they've said, make any changes on the one they fill out.
Okay. Yeah, that's good. So for people that are listening out there and they're maybe like they've been kicking the tires, should I, file? Should I pursue this? Do you have any insight, like what might be the best time to file, and has it changed? Like, is today's environment from an application submission strategy different than it has been in the past?
You have to remember that you have to prove you're going to be unable to work for 12 or more consecutive months.
Yep.
But if you're applying for SSI, your payment starts with the month after you applied.
Okay.
So for SSI, you should apply immediately because otherwise you're costing yourself money.
Got it.
If you're applying for Social Security disability, they don't pay for the first 5 months. That means I recommend applying when you've been off work 4 months. When
Okay.
they start reviewing your case, you've been off work 7 or 8 months.
Yep.
At that point, the reviewer can be comfortable that you're going to be off work 12 or more consecutive months. And they're more likely to approve the claim. If you apply right when you stop working, they're going to say, how does this person know they're going to be off work 12 months?
Mm-hmm.
Mhm.
Mm-hmm.
And let me get on my soapbox for a minute, because everybody should write their legislators and say, if we're going to be disabled for 12 or more consecutive months, why do we have to wait 5 months to get paid? Why can't we get paid starting with the first month we've been off work? And you don't get Medicare until you've been off work 29 months. Why shouldn't you get Medicare starting with the month you became disabled? And you should be writing your legislators and ask that, because that's just disgusting that they have those waiting periods.
Yeah. Something about saving money, I expect. I mean, what's the other logic, or is there any other?
The answer I always get is, well, we've always done it that way.
Yeah. Yeah.
That's not an excuse for continuing to do it that way.
No, no, there's this thing called change. Um, Speaking of changing, um, there's other variables for those that are applying. We talked about the time frame, fourth month. Okay, got that. Um, I'd like to get your insight on the impact of age and the work history for an application. And I don't expect this is going to impact what you just said, but regarding the timing, but I'd like to just dial in on those. Like somebody that is 45 versus 54 or 59. And, if they've had a different type of work history, an intermittent type of work history versus a solid career.
Older you are, the easier it is to get disability because the harder it is to learn a new job. There are some reps who won't take anybody under age 50. People like that shouldn't be allowed to practice. There are plenty of good cases for younger people, and you should be looking at the case and say, can I win this case?
Mhm.
It's harder to win a case for somebody under 50, but they can be won. You just have to work a little harder on that case.
Yeah.
Your work history is important. The more skilled your work, the tougher it is. It would be harder for you to get disability because your work is sedentary, it's skilled. There are a lot of things you could transfer your skills to do. The person who has worked in a factory and lifted 50-pound cases all day, every day, doesn't have the skills to transfer to do office work that would be lighter.
Mhm.
So your past work is a crucial consideration in whether or not you're entitled to disability.
Mhm. Yeah. Yeah, there's a lot there. I mean, um, for your career choice and what you're doing, what's the longevity of it. Because it's always better to work, in my opinion, than it is to have to, unfortunately, pursue disability. The system is there for those that need it, but I'm a
Of my
strong proponent.
clients, half of my clients actually return to work. When
Half?
I, yes, when I've testified in Congress, I've always told them that nobody ever wants to call me.
Right.
There's nobody who wants to get disability. And 2 or 3 years before someone calls me, they would have never imagined calling me. I'm the last resort when there's no other choice.
Yeah.
And it's just a matter of what's left. I can't work. I have nothing else to do. And usually it's give me the income while I'm trying to get back to work. One of my clients, in fact, has been off work for 2 years, and Monday he started working again 4 hours a day.
Beautiful.
He has
Love
a
that.
skilled position and he's able to do it, but um, he called me last Friday to tell me he was going to start. And did he have to drop his claim? And he doesn't have to drop his claim because he's got a hearing coming up and we're going to get him paid for the time he was off.
All right. Good. I don't know what you say, Jim, when you're out socially, when people ask you what you do, but one of the lines that I have is I say, listen, I'll tell you what I do, but first of all, you seem like a really nice person, and I hope you're never a client.
Right.
Right? That's the truth. I mean, it's unfortunate.
Well, now I usually say you're too old to ever be a client.
Yeah. Yeah. Um, Speaking of, the work that you do, we do, we do a lot of work to help people get through the system that they can do it on their own. That's part of what we do here at the Disability Digest. And Attorney Brown's out here donating his time very generously so that you can use this information to do that. But some people don't make it through the system and they're in need of representation, and some people would just prefer it. So my question next to you is, if you look at historically, like what's gone on with representation and the individual's mindset? Has it changed? Has the percentage increased of people that use representation now versus when you started in the 70s?
When I started, 8% of the people were represented.
Eight.
Um, the judges, people would go in, they'd have a hearing, the hearing referee would discuss the case with them. The hearing referees would then send for any evidence that was missing. if they needed to have another hearing after they got the evidence, they would schedule another hearing. The claimant would come in, they would talk about it, and they were approving 70% of the cases.
Wow.
During the Reagan years, that all changed. Now, Reagan wanted to cut 500,000 people a year off of disability.
Mm-hmm.
One of the reasons is because they changed the Social Security surplus to be part of the regular budget. So that made the deficit look smaller. Part of that, it wasn't all Reagan. Tip O'Neill, the Democrat, was Speaker of the House, and he went along with it. But they did that to make the deficit look smaller, get people off of disability. They made it much tougher to get disability. You had more forms to fill out. The judges had to write longer decisions. The judges who were approving more cases got reviewed more. So there was one judge who was approving 90% of the cases, and he was constantly under review to see why he was approving so many. He justified every one of them, but he got more cases sent back for a better explanation. And it was just a horrible system. A lot of the people who they tried to terminate committed suicide. One of my classic cases was somebody who got a letter saying, you have to prove you're still disabled. She didn't understand the letter. She ignored it. She then got a letter saying you have 30 days to prove you're still disabled. Didn't do anything. She then got a letter saying we're giving you an extra 10 days. Didn't do anything. And then she got a letter saying, since you didn't provide medical proof, you're apparently no longer severely mentally retarded, and we're terminating your benefits. Her brother brought her into me. I called the person who sent the letter, and I just gave him the Social Security number, and I said, pull this claim, and if you've cured her, you're going to win a Nobel Prize. He thanked me for not going to the newspapers or the television stations about him. And it did wonders for me getting along with the people at the state agency. And they got her back on disability immediately. But they were going after the people with mental disabilities first because they were least able to fight back.
So I want to that's an amazing story. I want to circle back on this a little bit. You said something about judge approving 77%. First of all, for those of you out there, that's like rock star status. I don't know if anybody does that now. But what you're communicating to me, is there something that stands out? Like, is that one of the reasons why from a applicant or disability benefit seeker that there's been a change in disability representation, like from 8% to whatever it is now? I don't even know. Do you know what it is now?
It's in the high 80s, high 80%.
So most, yeah. Okay.
There's a lot of reasons. First of all, it's easier to find representation. There weren't many of us representing people then.
Mm-hmm.
Second, that doesn't mean it's easy to find good representation. Secondly, the system has become far more complicated. They didn't used to have vocational experts at every hearing. Now it's rare not to have one.
Mm.
The vocational expert has to be cross-examined. That can be difficult. I had a hearing last year where I always sit at a hearing with two computers. One computer has all my client information, and the hearings are by telephone or video. The other computer is where I look up what the vocational expert is telling me. And he said my client could be a toy stuffer in a stuffed toy factory. And I asked when he had last seen this job, and he said 6 months ago in southeastern Ohio. So I immediately Googled toy stuffing jobs, Southeastern Ohio, and the last one left Ohio 7 years ago. So I started questioning him and I gave him the name of the company that left 7 years ago. And he said that's the company he saw it at. And I locked him into being sure that was the company he saw it at. And then I told him that that company left 7 years ago. That vocational witness actually got fired. The chief judge of the office asked if I was happy he got fired. I said, no, I'd rather he kept testifying and lying so that we could keep winning cases. I said, or he should have been indicted for perjury. But if you don't know what you're doing as an unrepresented individual, you can't cross-examine these vocational witnesses. Sometimes there's doctors there testifying. I had a doctor recently, my client had MS and Pott's disease. This doctor said my client didn't have either. And I had to go through probably a 40-minute cross-examination to get the doctor to admit she didn't know what she was talking about. The unrepresented claimant couldn't have a chance of doing that successfully.
Mm-hmm.
They would have just been turned down.
Mm-hmm.
So representation is far more important now than it ever has been. And it shouldn't be. The system should be easy enough that we should never get an easy case. But they've made it so that the cases aren't easy anymore.
Yeah, that's a good point. No, I mean, you and I have like views. That's why we have the Disability Digest. There's no charge for it. You get a disability approval course, has step by step what to say and do throughout the process. Attorney Brown, it's got some of the steps in there. So for people that are, I think one of the challenges that people struggle with is at the initial application, there is a mindset that I should just try it on my own. And if I get denied, then I'll find somebody to clean it up. So, um, and I think there's somebody's brother-in-law that's been running around out there spreading this whole thing. But on those particular mindsets, do you have any advice for people?
If you're going to file your claim on your own, make sure you include every impairment you have. The biggest mistake I see over and over and over is people who put the last thing that happened that made them stop working.
Okay.
I had a client who stopped working because he had back surgery, but he didn't put in that before that he'd had a stroke and a heart attack. The back surgery got him denied. When he came to me and I added in the stroke that left him partially paralyzed on one side and the heart attack that kept him from being in extremes of temperature, limited his exertion even more than the back surgery did, it was an easy case. Put in every impairment. If you broke your left big toe, put it in there. If you tore your rotator cuff, put it in there. List everything. You don't know which impairment is going to be the one to put you over the top.
Great advice. I just one thing I'll share from yesterday. We had an individual came to us, been denied, sent in the denial letter at the initial application, and in the explanation part at the end, there was one doctor. Well, he has 5 doctors, and so I replied back like, "What happened with the other ones?" He says, "Oh, I didn't think they were important. I didn't put them in. Only one doctor." So that didn't help either. Um, Jim, I want to pivot a little bit and out of like the technical part of the disability process, which has been awesome. And I wanted to ask you this, like in all, you've done work here and you've spoken at like conferences, seminars and stuff and all of that. Is there like, a certain speech that you've done that kind of stands out as like your all-timer?
in the 80s, I gave a speech probably 30 times around the nation titled, "There is no trust fund, there are no reserves." And people talk about the Social Security Trust Fund, and there isn't a trust fund. They've never put the Social Security surplus into a lockbox and taken care of it. They loan it to the government at the lowest possible interest rate, and then the government's supposed to pay it back to Social Security when they need it. And there are no Social Security reserves. So it is just a hoax that politicians talk about the Social Security Trust Fund, the Social Security reserves. And I
Wow.
gave that talk throughout the country because I wanted to wake people up. On the other hand, privatizing Social Security would have been a disaster because with the Social Security surplus, if it was privatized, that would have meant that Social Security was either buying bonds or buying stocks. So in 7 years, the Social Security Fund would have been controlling the stock market. And all of the people who don't want socialism would have had the Social Security Fund controlling the entire stock market. If a president didn't like Ford Motor Company, the president could have said, sell all of our Ford stock in the Social Security Fund and driven it down, or could have told the Social Security Fund to buy a certain stock and driven it up. And privatizing Social Security would be a nightmare. But that was probably the most meaningful talk I ever gave.
Yeah, I mean, just that snippet right now, I learned something. So there's a lot of noise about this Social Security fund. So,
But
thank you.
added to that, and back in the 80s, I was saying Social Security is not an entitlement. When money is taken out of your paycheck for Social Security, you're having a contract with the US government.
Mhm.
And they're taking the money out, and the government is promising to pay you a certain amount if you become disabled, to your family if you die, to your widow if or widower if they're disabled, to you upon retirement. And it's a contract. It's not an entitlement. And those people who say it's an entitlement are just trying to get out of paying you the money that you're entitled to receive, not as an entitlement, but as a contract with America.
Isn't there something in the language for Social Security, the word entitlement? Um, Sounds familiar. But anyway, I mean, if you look at it, the acronym SSDI, the I is insurance. It's insurance that you paid for. Yeah.
Right.
Um, okay, now I know you've done, I don't know how many hearings you've done. Do you have any idea how many hearings you've done?
I have no clue.
Yeah, a lot. Is there any one hearing that stands out? I've heard some of your snippets that are absolutely hilarious, and I don't know if that is any of these, but uh, anything?
I had one where my client had been illiterate and he was learning to read. And the judge said to him, "What made you want to learn to read?" And this man was in his early 30s. I was representing him because he'd had a terrible accident. And he said, "Well, when I got married and my wife was pregnant, and I wanted to be able to read to my child." And he said, "My child is now a year and a half old, and I can now read on a fifth grade level, a little better than fifth grade. And I'll always be learning to read better than my child so I can keep reading to them." And the judge thought that was very nice. And then he said, "Judge, can I tell you one more thing?" And the judge said, "Go ahead." He said, "The man who's been teaching me to read is this lawyer who's sitting here with me today."
Oh,
And
wow.
I taught two illiterate adults to read. And I didn't expect my client to say that to the judge, but every judge in the Cleveland hearing office found out I was teaching illiterate adults to read. I had created the Volunteer Lawyers for Literacy, and we had over 100 lawyers in Cleveland teaching illiterate adults to read.
Good for you. That is awesome. Yeah. What was the judge's response?
The judge took about 5 minutes more in the hearing. He was so awestruck by it that he basically wrapped up the hearing and approved the claim.
Beautiful. Rightly so. Um, let's talk about one lesson. There's one lesson that you've learned that you could take and communicate out there for all of these years of experience to people. Let's target it to people for those that have not applied. Like, what's the one lesson, if there is one? Putting you on the spot here, I know, but I think you got it.
This is an easy one. You have to be seeing qualified medical providers. You have to be seeing them regularly. You have to be telling them what's wrong. Don't exaggerate. If you're exaggerating, a doctor can tell.
Okay.
But tell them what's wrong. Make sure you're getting, if you need specialists, see the specialists. It's hard in some states. There's no Medicaid in too many states.
Yeah.
But too many people apply for Social Security and they're not getting medical care. Social Security isn't going to send you to doctors to prove your claim.
No.
So you need qualified medical providers. People come to me and say, send me to a doctor who will say I'm disabled. There are plenty of doctors who will say whatever you want them to say, and nobody believes them. I always start with my client's primary care physician, any specialist. If somebody says you have fibromyalgia, you should be seeing a specialist for it. It's too often a garbage term that family doctors use.
Yeah.
If somebody says you have POTS, you should be seeing a neurologist or a cardiologist. But you have to be seeing the right specialist, the right medical providers, and they don't have to say you're disabled. They just have to say what's wrong with you and what your limitations are.
Yeah. And a lot of that comes from the patient, right? So
Absolutely.
that's really, really good advice.
One of the things that I recommend is bring a piece of paper or notebook paper or something with you to hand to the doctor with your problems. Because the doctor may not have time to ask you all of them, but they'll put that in your record.
Yeah. Before we get into Q&A, which we will in a moment for everybody, so get ready. If you have your questions, line them up, or Nadine will give you guidance as to how to come in here and talk to us. I have one last question for you, right?
You ready?
We've talked about your birthday you just celebrated. I mean, you could have been done probably and not working long time ago. I'm glad you're not. But I'm just saying, what keeps you doing this? I mean, you're busy. You're on the move and you're still actually representing claimants. Why?
In the 80s and 90s, I had created the Volunteer Lawyers for the Homeless in Cuyahoga County, which is the county Cleveland is in. And we had a lawyer going to every homeless shelter in the county once a month just to answer legal questions. I was in one shelter, and my wife pointed out a woman with 6 stepladder children who just looked like she didn't belong there.
Okay.
And she sent me over to talk to her. And the woman said her husband died. He'd worked in the steel mills for 19 years, and now her house was being foreclosed on. And I said, well, what about his life insurance policy from the mill? And she said, what life insurance policy? This was on a Sunday night. Her house was being foreclosed on in 8 days. And she didn't know she had life insurance. And I said, what about his pension from the mill? And she said, what pension? She didn't know she had that coming. And I said, are you getting Social Security? And she wasn't. Nobody told her she was entitled to survivor's benefits for her kids. So I gave her the name of the human resource director for the mill, who was a friend of mine. And I said, tell him if you don't have your money by Thursday, I'm going to sue him personally, which he knew I wouldn't. But on Thursday, she got a $50,000 life insurance check. She paid off her mortgage. Between her Social Security and her pension, in 1993, she was getting $5,000 a month.
Okay.
So she moved back into her suburban home,
Beautiful.
put her kids back in their suburban school. And 6 months later, she showed up with her 7-year-old son with a tray of cookies for everybody in my office. And her son said, Mr. James, I love you. And I said, Daquan, what does I love you mean? And he paused for a minute and he said, it means you make my heart smile. And Daquan is now 33 years old. He and 4 of his siblings have graduated from college. The 5th one has made a career in the military. And Daquan's married with 2 kids. Their mother died 2 years ago. But since 1993, I've wanted to make someone's heart smile every day.
Beautiful.
And doing my work is one way, doing my volunteering is another way. But I've thought about what he said every day since he told me that. And that's why I try not to slow down.
Yeah. Yeah. That's great advice. I mean, it's got me choked up, rightly so. That's powerful. I think there's also a message for people out there that find themselves, either in transition out of their work or whatever their situation is finding what Jim has just communicated. I'll put it in one word if I could, allow me. Purpose.
Right ahead.
Purpose. Purpose. Right.
Well,
You
I'll
fi-
give you 2 words.
All
Ben
right.
Franklin lived to be 84 when the life expectancy was 36.
Yep.
And somebody asked him how you get to be as old as he was. And he said, be useful.
Be useful. Yeah. Yeah, we're put here for a reason. That's my Christian belief, to serve. So yeah, really good. That's a great note to, well, transition on. We're not ending because we're gonna take some questions. So Nadine, if I may, I will turn it over to you to bring us forward.
Or
Yeah.
we've gone to the most awaited part of this show, the Q&A. But before that, I would like to personally thank you, Attorney James Mitchell Brown. Jim, thank you so much for 52 years of wisdom that you shared with us today. Our hearts are truly smiling right now for everything that
You
you
made my
shared.
day then.
Yeah,
And
that's beautiful.
before we answer the questions from YouTube and Facebook, I would like to also give Mr. Philip Price the opportunity to ask questions from his Facebook group.
All right. First, I would like to, with Brian's permission, a little plug for my group, and wanted to say, if you're out there listening to today's live, first of all, thank Mr. Brown for being here with his knowledge, years of knowledge. And if you're out there listening, if you join my Facebook group, when I approve you into the group, I send you an invite to join the Disability Digest. So please do. All right, let's get off with the first questions here.
Permission granted.
All right, I did it anyway. So, all right, first question here, and this ought to be familiar, Mr. Brown, because this was in your.
When did you start calling me Mr.?
All right, Jim.
After 53 years.
It's just my upbringing. Okay, first one says, with multiple sclerosis, I'm not working, got a lawyer, seeing a neurologist. What are my chances My hearing is June 10th of 26. That sound familiar?
Sounds like a lot of clients I've had. It depends what your limitations are. Do you have trouble walking, getting out of chairs, standing in one place, lifting things? And will your neurologist support all of that?
Hmm.
If the neurologist will complete a medical source statement, it will do wonders for your claim.
Yep. Jim, also, what about the age? Work.
With MS, age isn't as important. I've won a lot of younger people with MS with a good medical source statement because the physical limitations are so severe,
Got it.
or can be.
Okay.
All right, next one here. This one's a little long, so bear with me. It says, I was recently let go by my attorney. I'm 5 years in with them, and we are at the final stages, and they told me that even though my medical issues would qualify me, the fact that I'm working part-time making over the SGA would immediately disqualify me. It's taken 5 years and I've gone back to part-time work. So why didn't the attorney tell me this sooner? Did I mention it was a huge law firm and I spoke with them about 4 times over the 5 years? They did nothing. My question is, what if I cut back now to go under the SGA amount? Will this help me still continue with SSA?
That question has about 11 parts to it. I get a lot of people who come to me who have worked right up to the SGA limit and get cut off because they've said, I could earn more, but I don't want to lose my disability. So here's somebody who says, I would cut back to be eligible for disability, which is saying I could make more, but I don't want to. The better question, and I wonder if he had a law firm or a non-attorney firm, one of the national mega firms representing him that doesn't communicate. But did he have 12 or more consecutive months earning less than SGA? If he did, he would be entitled to disability for those periods. And if he had 12 or 15 or 24 months of earnings below SGA, he should contact another representative and say, I was unable to make SGA for this period of time. Can you help me get disability for that period? I have found judges are very favorable toward closed periods where you're just saying, I only want it for this period of time.
Yeah. They're not on the hook for a big bill.
All right, next one here. It says, can we talk continuing disability? I'm a bit confused as I was deemed fully disabled.
Social Security doesn't give anybody permanent and total disability. The law says they have to be reviewed every 3 years. Sometimes they get reviewed every 2.5 years. Sometimes it's every 4 years, but you get reviewed. That's why you have to continue going to a doctor. You have to continue telling the doctors your problems, and you have to have medical care when that review comes up.
Okay. Last one here says, does SSDI add your minor children automatically, or do you have to request it once approved?
Well, you should have put the minor children on your application when you filed. You then have to go into the local office and fill out another form for the minor children. They will be paid going back to the date of your application. If you didn't put them on your application, they will only be paid from the date you go in and add them.
Mhm.
All right, Nadine, that was the last one from the group for today.
Nadine, we
Thank
have
you.
somebody that has requested to join the room. I'll let them in. And
Oh,
do I need
okay.
to, let me see if you are, there you go.
Hello. Hi there. You are showing us an iPhone, if you don't mind introducing yourself to us.
Oh, are you talking to me?
Yes,
Oh,
hi
okay,
there.
I'm sorry. Um, last year I'm 62. So last year when I was 61, I had C-spine operation, and it's been a year since I worked. And so every time I mean, I could walk about 800 steps before my legs get weak, and I can't walk anymore. So sh should I how would I get disability first of all? And second of all, should I get my Social Security, my retirement right now? Not retire. You know what I'm talking about?
Okay, your retirement will be 30% less
Yes,
than if you were at full retirement age.
exactly.
But you should sign up for disability. When you sign up for disability, it will ask if you want your early retirement.
Yes,
Do you need the money now?
yes.
Then take the early retirement, but when they grant you disability, they'll raise the rate to the full retirement rate.
Okay. So what's the chances you think they'll grant me? I'm 62. Grant me disability. I had a heart attack back in 2022. Also, I had a stent put in.
Do you still have any chest pains?
No,
Do you have any restrictions because of the heart attack?
no,
You're not told not to be in extremely cold or extremely warm weather?
not from what my doctor told me. No,
I didn't hear you.
not from what my doctor said. He didn't say anything.
Okay. Um, Having had a heart attack and the spine surgery, you have a good chance of getting disability.
Okay. And how long is the process?
What state are you in?
California.
Probably about 6 months.
6 months. Okay. Well, I appreciate that. Thank you so much.
Sure thing.
All right, thank you so much. Although we didn't get his name, but thank you so much for participating. And while we wait for other viewers who would like to join us and ask their questions live, I do have a couple of questions here from the comments. But before that, I just want to read one comment here for you guys. She said, listening to you guys, I mentioned to SSA about the grid rule, and she was about to fell off her chair. She never had anyone know about the grid rules. So it's a good thing that you're learning from us. Okay, so one of the questions that we have here, were more people approved for disability in the past compared to today? And
Ooh,
if there were more people, why, and has something changed?
great question.
Number wise, more people are approved today, but that's because more people are applying. Percentage wise, less people are approved today, and that's because they've made it harder to get disability. They've made the vocational rules tougher. They made it tougher medically to get it. They haven't changed the law. They've just changed the procedures to make it tougher.
All right, next question. can a judge refuse to accept additional medical evidence? And how should you handle that?
Judges can do whatever they want, but I had a judge refuse to accept additional evidence. All the evidence has to be filed 5 days before the hearing. I had some evidence come in 4 days before the hearing. I filed it. The judge said he wasn't going to accept it. He denied the claim. I appealed the denial. The appeals counsel said he should have considered that evidence that came in 4 days before the hearing and sent it back for a new hearing. So
Mhm.
if the judge doesn't accept the evidence, then appeal, and you should get them to order it to be considered.
Okay, that's a very helpful information. All right, I think we have a Dennis Pedretti who wants to join. Oh, he just left. Dennis, if you want to rejoin, please do so, and we will let you in. While we wait for Dennis to go back in the room, we have another question here. Can a CE or SSA doctor visit actually help you get your claim approved?
Sometimes. It depends what's wrong. It depends who the doctor is. I've had some mental health exams that have been great. There was one mental health doctor who was a total fraud. And it just depends. There's one doctor who's an internist who does all these orthopedic exams. And sometimes she is wonderful helping people get their disability. And sometimes I don't know if she even examined the people because they seem to be in such bad shape and she finds nothing wrong with them. But it depends on the physician. It depends on what's wrong with you. And sometimes I think it depends on the day you're examined.
Oh, really? Is there a certain day that's not as good about as others?
No, I just think it's that physician's day.
I see. They might have had a bad day. That
Right.
happens.
Interesting. All right, another question here. Does the initial SSA decision take into consideration the grid rules?
It's supposed to, but the people making that initial decision don't really understand the grids. So, although they're supposed to get a vocational opinion and a medical opinion, it's like people in 3 silos. And they don't speak the same language. So
Mhm.
sometimes they take it into consideration, sometimes they don't. It depends how experienced they are.
All right. Another question here. How does Social Security decide what transferable skills or jobs you can still do, especially for people over 55?
That's a tough one, figuring out how Social Security decides something.
Mhm.
I had somebody who had been a secretary for about 6 months and then a truck driver for 4.5 years. And Social Security decided that her skills as a secretary were transferable, even though the vocational witness said everything that she learned as a secretary 5 years prior had nothing to do with what a secretary would do today. But the judge still thought those were transferable skills, went against his vocational expert. So if you could figure out what they're doing and why, I had a case that this was one with the worst judge in the country. She only approves 4% of the claims.
Oh my God.
And she said this person did clerical work. The person lifted 50-pound cases 6 hours a day, and 2 hours a day, she typed in a computer what the cases were that she had lifted for 6 hours. And the judge said she had a clerical job. Even though the vocational witness didn't call it clerical, the judge determined that it was clerical. So you're at their mercy sometimes, and that's what appeals are for.
All right, so we have a B in the waiting room. I have just let B in. Hi, B.
Hi, B.
You are muted. I'm going to ask you to unmute. Oops. Okay, while we wait for B to figure out how to unmute his or her microphone, we still have a couple of questions here. This one is interesting, and I think either Brian or Jim can answer this question. How do you feel about AI helping with filling out the online application for SSDI?
I think AI misses a lot of the reasons why someone's disabled. I've seen AI do some, and it doesn't get into the real details of why a person's disabled.
Yeah. My 2 cents on that is I don't see, knowing the initial application where it's basically data entry, and when you enter your doctors, your medications, your work history into the initial application, I don't see AI as being a tool to benefit that. There's a lot of people out there, perhaps you can speak to this, Jim, that are like, I submitted my initial application, I hit the send button, I'm just going to wait and see. But really, I mean, that's maybe 2% of what is actually going to influence your case. Maybe Jim has a different percentage than I, but it's just the data, right?
Right?
Where I do see AI being helpful is, for example, we had a client the other day who used AI, and she took a prompt from one of those lessons that we did online, and she entered her age, her limitations, her doctor's treatment, or work history, and she asked AI to create a explanation as to why she was not able to work, right? So something like that, definitely, because it's a thinking partner. So that's my.
I saw one where AI gave all the explanations why this person couldn't work. It's just that it had nothing to do with that person.
Yeah, you definitely have to proofread it. But
Right.
Okay, another question here. SSA said they'll handle CDRs in-house now. What does that mean for reviews, and will it change how short form CDRs are handled?
We've always handled them in-house. I don't know what that means. They've always had some case managers at the DDS in each state who handled the CDRs. Does that mean they're going to let all of them handle them? They were doing a much better job limiting the people doing CDRs, having just a few do them.
All right. Another question here from Bill. How can I get a medical source form?
Brian, you can answer that from Disability Digest.
yeah, so when you join the Disability Digest as a member, you'll get directed into our disability approval course, and in there you'll have access to medical source statements, residual functional capacity reports that you can listen to an interview, understand why they're important, how to fill them out, get the forms, and be on your way. So that's how you can access them.
All right. Got one last question here from the comment section of, please explain why a vocational specialist is so influential in determining whether you're disabled enough to stay home. If adaptive equipment is not provided when needed and prescribed, then what?
Vocational experts shouldn't be so important on the case. Because of some court rulings and because of the commissioner 2 commissioners ago, they made the vocational experts more important. There are some judges who still don't have vocational experts at the hearings. Other judges have them. Most judges have them at every hearing. And they have to look at your vocational limitations. You don't have to stay home to get disability. There are plenty of people who are disabled who can go out to the grocery store. They can go watch their kids at their sporting events. That doesn't mean you can go work 8 hours a day, 5 days a week.
Yes.
So the fact that a vocational witness says you can do certain things, the vocational witness is answering a hypothetical question from the judge. The judge says, assume I have a person of this claimant's age, education, vocational background who's limited to light work. Can they do their past work? Can they do any other jobs? If you're limited to light work, there's plenty of jobs you can do. It's then up to your representative to show why you can't do those jobs. If the judge said, assume that this person is going to be off task, meaning because of their physical or mental problems, they wouldn't be paying attention to their job 15% of the day, then they're unemployable. Assume they would miss work 2 days a month. They're unemployable. That means you'd have 24 absences a year.
Yeah.
So the vocational witness, if they're honest vocational witnesses, are only answering the questions the judge gave and the lawyer gave. Now, I have a lot of vocational witnesses who try not to be honest when they answer my questions. And then I have to dig deep into the basement of my mind and come up with questions to get them. I had one where I had some excellent proof last week, and I asked her a really complicated question, but it was based on a vocational report from the claimant's workers' comp case. And the judge said, she's not qualified to answer that question. And I said, Judge, she's your expert. She should be able to answer it. And the vocational witness said, I'm qualified to answer that question. She then said, based on that vocational report, this person would have to be like a special needs person. And I spent 5 years working with special needs people, and he couldn't do any job without an aide with him, helping him in that job, which would be an accommodation that precludes employment. The judge was not happy with her answer, but he knew that meant I won my case. The good vocational witnesses will always give you an honest answer, but it depends on the questions they're asked.
Mm-hmm. Yeah. And, had you not countered with a good question, right, that
Right.
case likely would not have been approved. Yeah.
I had one complaint filed against me by a judge when I asked 36 hypotheticals, taking an hour and 37 minutes.
Mm-hmm.
And the judge said I wasted his time, his court's time, and the time of the lawyers waiting for hearings after me. And the OGC attorney who got the complaint wrote him back and said he filed his complaint improperly and he shouldn't complain again about lawyers properly representing their clients.
Wow.
So, and this was a judge I just didn't trust, so I had to get every possible combination of question in.
Mhm.
So it's just a matter of how do you properly represent your client. There's one judge who knows what I will do if I have to counter a bad vocational witness. And she often says, Mr. Brown, I'm going to approve this claim if you agree not to ask any questions. And she knows how to shut me up.
Yeah. Yeah. That's a pretty fair deal, actually, right?
It's a great deal.
Yeah. Yeah. That's beautiful. All right, Nadine, was that it?
Yeah, I know I said that that was supposed to be the last question, but we do have a buzzer beater, and I think her question is something important for everyone to hear. So the question is about, does your chances of getting approved improve if you use an attorney or representation, and how do they get paid?
That's a great question. Your chances of winning improve if you're represented, but it means you have to be represented by somebody who knows what they're doing. There are plenty of representatives, attorneys and non-attorneys, who don't have a clue how to cross-examine the vocational witness, who don't take any continuing ed classes in Social Security. So you should ask the person you're going to hire if they belong to NADR, NADR, NASCAR, or ACRD. Those are the three organizations for people who represent claimants on disability claims. And ask them how many hours of continuing ed credit they get on Social Security disability law. If they're not going to classes to learn how to better represent you, then they're going to do things the way they always used to do them and not know the most modern ways.
Mhm.
And if it's one of the mega firms, you're going to want to say, when do I get to meet the attorney or the representative who's going to take my case? If you're calling somebody who says, you're talking to the person who's going to take your case, maybe they're a good representative, maybe they're not. But you can at least ask them those questions. If you're talking to somebody who says, we don't assign your hearing until 30 days, your representative until 30 days before the hearing, you're talking to a factory. And are they going to really represent you well? You ask them, how often do you communicate with me? How often do you find out what's going on in my case, in my condition? And you want to find out if they're going to care about you.
Yeah.
If you have a representative who never reaches out to see how you're doing until they get a hearing notice, that means they're not going to do anything on the initial app. They're not going to do anything on the reconsideration. And then they're going to scramble to represent you when they get the hearing notice. So if you're well represented, you do much better with a representative. If you just hire somebody, anybody off the street, you might as well go in alone. There's one representative I know who, in the hearing office where his practice is, they're paying 42% of the cases, and he wins 25%. People are better off not having him.
Yeah.
Mhm.
But look to see how that representative does and what they do while they're representing you to make sure they have all your current information.
Mhm. Yeah. You know, it's interesting. Just I'll add a few thoughts on this. If it's really expensive, in my opinion, experience, to have bad representation or not so good representation, because it'll likely go the distance, which means you're going to go to a hearing and pay full fee if they get it approved, or you might not get it approved, or because it's not worked from the beginning. Alternatively, if you look at having a representative that's going to work your case from the very beginning and you get approved. In an example like Jim said, where you apply at month 4 and you get approved at maybe month 8 or 9, the amount that you pay for representation out of your back benefits could be $3,000-$4,000 out of your back benefits. Now, if you don't get it right there, you're going to go on to a hearing. So you have to really, I think that's a great question, super reply. Evaluate the best way to get your benefits. How we can help you as we wrap up here at the Disability Digest is our membership, there's no charge for it. And when you join us, you click a green button. Nadine will put a link in the YouTube chat if you haven't joined us already. And that profile will put you into the right information, like in touch with an advocate. And the advocate will put you into the disability approval course. Let's say you're already represented or you want to use another representative. Now, right now, if that's the case, do you really know what needs to be done? Do you know how the forms should be filled out? Do you know what you need for an RFC? Do you know what to do when you go to an independent medical exam? Well, if you're using the disability approval course and a representative, you can have a check and balance system. That's one of the beauties of it. So if you're out there and you're like, oh, it sounds all good, but I already got somebody on my team, it doesn't matter. You can come on in. We can still be very efficient and help you and make a difference for you. So whatever you decide, whether you want to use somebody else, whether you want to come in here and do it on your own, whether you're like, oh man, that Jim Brown, he's like, I want to talk to that guy. Just come in, ask an advocate, or you can use a representative service that we provide. So those are the options that you have here. Or if you're already approved, there's a whole host of other information, including a continuing disability, how to survive your continuing disability review course, put together by none other than Mr. James Mitchell Brown here. So that's it. All right. Anything else before we wrap today?
Yeah, so in respect of time, I know there's still a lot of questions in the comments in Facebook. So there's going to be a replay. This live event is being recorded, so you can still continue to put in your questions and we will do our best to answer them via comments later.
Yes. Beautiful. Beautiful, beautiful. This has been a great event. Thank you for sharing your historical experience in working in this industry. Amazing, powerful, and very touching closing question, and how why you're still doing this, which is great because, like I said,
Thanks for letting me share.
yeah, another 10 years, right?
Happy birthday again.
Why
Yeah.
just 10?
10. I like it. I like the attitude. Good. Well, I appreciate you, Jim. Thank you for joining. Philip, Nadine, as always, appreciate your contribution. All you out there, we'll be back in 2 weeks for another live show. Mark your calendars. Make it a great day. God bless
See you
everybody.
in a couple
Thank you.
months.
See ya.